You rented a house from the defendant?
Yes.
How much was the rent?
$525 per month.
And did you give him security deposit?
No, I gave him $1,000 security deposit.
Show me proof that you gave him $1,000 security deposit.
I don't have it.
Okay.
Judge begins the case by asking basic questions about the rental agreement. The plaintiffs explain that they rented a house from the defendant and the monthly rent was $525. They also claim that they gave him a $1,000 security deposit. However, when Judge asks them to show proof of that payment, they say they do not have any proof anymore. This becomes a major problem for their case. So, what happened next?
He told you that the house had to be renovated or something.
Yes, ma'am.
You had to move into another house.
Yes, ma'am.
Where did you go?
Well, he said he had another place for us to go to. He had another property that we could stay for the 2 weeks while the renovation was being done.
Fine. So did you go there?
Yes, ma'am.
The plaintiffs explain that the defendant told them the house needed renovation. Because of this, he asked them to move to another house for about 2 weeks. He said he had another property where they could stay during the renovation. The plaintiffs trusted him and moved to that other house. Interesting thing coming now.
And then the real owner came of that property.
Yes, ma'am.
Yes, ma'am.
And threw you out.
Yes, he came with the police.
Okay. Because she didn't know that you were squatting in her house. Who owned the house?
Jimmy.
How did you have access to the house?
Well, I had access to the house because I'm the RA, which is the resident assistant.
Resident assistant what?
He has about 10 properties.
Oh, so you had keys to the house?
Yes.
Okay.
And there was a lockbox
I got it. Yeah, I got it. Okay. So then the real owner came with the police and said, now you have to go because you're squatting in my house. I don't know who you are.
Yes, ma'am.
Okay.
The plaintiffs explained that while they were staying in the second house, the real owner of the property came with the police. She told them they had to leave because she did not know them and believed they were squatting in her house. The owner's name was Jenny. Judge then asks the defendant how he had access to that house. He explains that he had keys to the property because he worked as a resident assistant and managed several properties. However, the real owner had not given permission for the plaintiffs to stay there, which is why she removed them from the house.
Where did you go?
We went to a hotel.
And you didn't pay him rent in June?
No, we didn't pay him rent in June.
And did you pay May's rent?
No, we didn't pay him rent.
So you didn't pay May's rent either?
No, ma'am.
After the real owner came and removed them from the property, the plaintiffs went to stay in a hotel. Judge then asks about the rent payments. The plaintiffs admit that they did not pay rent for May or June. This means they stayed in the other person's house for a few days and later moved to a hotel, but they did not pay rent for those months.
And you have no proof that you gave him $1,000 security deposit?
No, ma'am.
So what would you like me to do for you? I mean, what's your damage?
The damages are punitive damages, Your Honor. In the process of all of this, I lost my job. I wasn't able to get to work. I had to resign my work because I needed to find another place to stay. I overdrafted my bank account because I immediately didn't have available funds to rent a motel for $300. I did have $500 that I was making payments.
Judge asks the plaintiffs if they have proof of the $1,000 security deposit, and they admit they do not have any proof anymore. She then asks what damages they suffered because of the situation. The plaintiffs explain that they lost their job, had to resign to find a place to stay, and overdraft their bank account to pay for a hotel. Judge clarifies that the defendant is not responsible for paying them for these personal hardships. This shows that without proper documentation or lease proof, claims for personal losses cannot be enforced, and only verifiable damages may be considered.
Do you have a lease?
No, but
Listen to me. Do you have a lease?
No, ma'am, not anymore.
You never had a lease with him?
No, ma'am.
He didn't bring it. He said he would. He never did.
Okay. So we have nothing. Now you have a counterclaim. Your counterclaim says that they damaged the property.
Yes.
Do you own the property?
No, I do not.
Just tell me what I need to know.
Okay. I have a lease from the owner showing that I was also renting from the same house. I just sublet.
Your Honor, he did not live
We're
there
done.
at all.
Judge asks if the plaintiffs have a lease, and they admit they do not have it anymore. She points out that they never had a lease with the defendant, and the defendant also did not provide it as promised. Without a lease, there is no proof of a rental agreement, so the plaintiffs' claims are weak. The plaintiffs then try to make a counterclaim saying the tenants damaged the property. Judge clarifies whether they own the property, and they admit they do not own it. The tenants explain they had a lease from the owner and were only subletting, and that the defendant did not live there at all. Judge concludes that there is no valid claim or counterclaim and ends this part of the case. Lesson from the case. This case teaches a general lesson about the importance of clear agreements and proper documentation in any rental or housing situation. Without written leases, receipts, or proof of payments, claims and disputes become weak and difficult to enforce. Verbal promises or informal arrangements are not enough to protect either party. It also shows that making counterclaims without proper ownership or authority over a property is ineffective. Keeping accurate records of payments, deposits, and communications can prevent misunderstandings and legal complications. Overall, the case emphasizes that responsibility, transparency, and proper paperwork are essential in any rental or housing arrangement, and neglecting these basics can lead to financial loss, wasted time, and unnecessary stress.